Hello, my name is Shawn Kraft, and I've had the pleasure of serving Airdrie and surrounding area since 2013. Today I'm going to talk about wills and estates law. There are three main documents when it comes to wills and estates planning. The first, of course, is the will itself. The will is important because it speaks at the deceased's death, and it talks about who is going to take care of their estate, who is going to be the guardian of any dependents they may have, and they're also going to be responsible for distributing the assets to the beneficiaries. The first and most important role that we name in a will is the executor, or also known as the personal representative. This is someone who we want to pick to be responsible and who is comfortable speaking with lawyers and accountants if necessary, as well as dealing with many different banks and financial institutions. The executor's role, of course, is to gather the information in regards to the assets and any potential liabilities that the deceased may have at the time of their passing, as well as distribute the assets to the beneficiaries in accordance with the will. The next person, which is important if it's relevant, is a guardian for any dependent children or dependent adult children you may have. The guardian may or may not be the same person as the executor, but it is important that the guardian is someone who the dependents know and feel comfortable with. If a tragedy should occur and your children or dependent adult child should need to go and be taken care of the guardian, it's important that they have a relationship already. The next important thing in the will is to consider who the beneficiaries are going to be for gifts. There's two types of gifts generally in a will, or at least most commonly. The first is known as a specific gift. This is where we have a specific item given to a specific person. A specific gift can be a family heirloom, such as a sewing basket or a clock. It can be jewelry. It can be specific sums of money given to a specific person, niece, nephew, or friend. And these items can be easily changed through amendments. So if gifts change or relationships change throughout the course of the life of the will prior to your passing, it's something that can be modified easily. The next gift, or the next portion of the gift, is called the residue. Once the specific gifts are addressed, the residue is everything remaining left over in your estate. The residue is often named beneficiaries of one or more people, most commonly your children. The most common is, I leave the residue of my estate equally to all children, but of course we can leave gifts of the residue in different proportions as well. Those are the most important elements of the will. Now I want to talk about the power of attorney. A power of attorney can be either springing, which means it doesn't become effective right when it's signed, or it can be immediate, which means that it does become effective when it's signed. The power of attorney is a document where we name somebody as our attorney to assist us while we're still alive with our financial decisions and our financial requirements. The third document when it comes to wills and estates planning is called a personal directive, or some people know it as a living will. The personal directive addresses our healthcare and living decisions while we're alive, but can't do so on our own. In the personal directive, we appoint an agent who is someone, again, who we trust, who cares for us, and who is going to be someone who makes the right decision for us, especially for our healthcare and living arrangements. For any other questions in regards to estate planning documents or estate administration in general, you can check out my Facebook page. And otherwise, thank you and goodbye for now.